Hi, so there have recently been criticisms of Justice Gorsuch's opinion in Bostock versus Clayton County. Bostock versus Clayton County is a very important case which deals with the Civil, Civil Rights Act of 1964. Civil Rights Act of 1964 has a Title VII, which prohibits discrimination by employers on the basis of few protected characteristics, one of which is sex. The case before the court was whether this protected characteristic of sex in Title VII of Civil Rights Act of 1964 also includes within itself the categories of sexual orientation and or gender orientation. This case consisted of three cases essentially bunched up together and would also have far-reaching consequences in the future. So there have been criticisms of this ruling. One of the person who has criticized this ruling is Edward Fraser, who is a philosopher and can be perhaps most accurately described as a Thomist philosopher. He blames this ruling on the philosophy of new natural law theory, which is basically a version of natural law theory, but is slightly different than it. And Fraser himself is a proponent of the original natural law theory. Fraser believes that the philosophy behind natural law theory could be thought to be in some form related to this reasoning, and he blames that uh, Gorsuch's decision is somewhat related to the philosophy of John Finnis, who is, as he believes, the foremost proponent of this new natural law theory. Fraser does not say much here, but just that the reasoning adopted by Gorsuch is tortuous and sophistical and links to other sources. So let's read those sources and try to analyze the arguments within them. So the first source that Fraser links is an article by Robert George. George uh, says in his opening sentence, I have spent much of today and this evening reading and rereading the opinions in Bostock versus Clayton County. He goes on to say that he respects Neil Gorsuch, but he does not understand how he reached these conclusions, and he believes that the arguments presented by Gorsuch are sophistry, and the position that he has endorsed is untenable. He agrees with Alito's dissent and cites Alito's opening sentence as devastatingly accurate. There is only one word for what the court has done today: legislation. George points out that this ruling would have far reaching consequences, including the eventual destruction of all women's sports. This issue is an issue of political flashpoint in American society as of today. This is a very important issue and is redefining the boundaries of conservatism and progressivism. And this is something that conservatives have been trying to uh, uh, put forward in order to point out the flaws in the progressive doctrine. So, this issue is very important uh, in the current context, and this is the reason why this opinion is also very important, because of its far-reaching consequences. Otherwise, also because it deals with Civil Rights Act of 1964 and is about a very important thing, which is Title VII in it, and would have consequences for employers all over the country of United States of America. This ruling would have significant impact on culture and on politics. So here he talks about how it is important to know all the logical presuppositions and logical entailments of a decision, which is a good advice to remember in general. He argues that the court has not applied the law as written, it has rewritten the law. And this is the crux of his argument, that this ruling is bad in the sense that It is neither originalist nor textualist, and thus deviates from the conservative principle, the principle that conservatives have adopted towards the system of justice. He says further in the text that this shows why the conservative strategy of appointing originalist and textualist judges is simply hopeless, and he has an argument for it. Because the progressives continuously change the boundaries of justice, one must ask whether trying to protect the system in itself becomes unfeasible at some point. And this is a very important question, and it relates to the philosophical problem of ship of thesis. At what point would the justice system become so different than what conservatives are trying to protect that originalism or textualism would become essentially a dogma to protect non-originalist or non-textualist interpretation of statutes and laws? And he says nearly all Democrat appointed judges and half the Republican appointed judges refuse to play by the rules of originalist and textualist interpretation. And this is somehow harming the conservative cause. And he is right about it. It's like that the rules of the judicial system are being observed by only one side, and that side is facing consequences of following the rules, which are negative because they don't have the leeway in turning the opinions in their favor, but have to grant some of the rulings in the favor of the progressives. So basically, it is a deformed game in which only one side can score a goal and the other side can only defend. He also tries to defend Gorsuch in a sort of way by saying that people questioning Gorsuch's good faith and saying that he betrayed the conservative movement and the Republican Party are somewhat wrong because the duty of Gorsuch should be towards authentic textualism, constitution, and laws. And thus, Gorsuch is not a conservative nominee to the Supreme Court or could be expected to write conservative rulings from the bench. However, uh, in providing a textualist analysis, he believes that Gorsuch has failed, and that is the criticism that he is using against Justice Gorsuch. So basically, he's saying that the main criticism of Gorsuch should be that he failed to practice what he was desiring, authentic textualism, and he failed to faithfully apply constitution and laws as written. And he points to other Republican appointees doing that. Such failures, he argues, always wound the rule of law. Coming on top of so many other cases in recent decades, he says, this one may finally discredit it in the eyes of many who have struggled to retain their faith in it. This is an article that does not analyze the Bostock ruling as much, but he has another article which discusses some points raised in Bostock versus Clayton County. So let's read that. This is about Title VII cases and textualism. Here he is giving the arguments. So after discussing the background, let's look at the arguments. He describes the error as succinctly as possible. He says, Justice Gorsuch supposes that discriminating based on orientation or gender identity always entails discrimination based on sex, because orientation and gender identity vary with sex. He argues that discrimination in the sense relevant to this part of Title VII concerns intent, about which he is right. And as a moment's reflection shows, one's intent, as well as any underlying beliefs and attitudes, can fix on feature X of a situation and not feature Y, even when X always comes with Y. This is the problem in analysis of George, and this shows perhaps a lack of legal understanding and the previous history of rulings on Title VII cases. So he's right that Title VII concerns intent, and there can be no discrimination without intent. He's right about that, but he's wrong about this statement. So, this is talking about a problem while analyzing the cases of discrimination. So, the feature X, discrimination against that feature has been prohibited by Civil Rights Act of 1964. Let's assume that. But this feature X is also linked with Y in some sense. Can a discrimination based on Y be a discrimination based on X? George argues that that cannot be the case, and he is right to some extent. It is not philosophically apt to argue that a discrimination based on something that is entailed by the characteristic which is meant to be protected, is a discrimination based on that characteristic. However, this is not what the previous cases around Title VII have been like. The whole point of putting Title VII in place in Civil Rights Act of 1964 was to uh, prevent discrimination based on these characteristics, these Y characteristics that come with X. For example, assume that a lot of categories which Title VII protects, they deal with the differences, actual differences in groups, one of which is obviously sex, and that is something that we would focus on. When Title VII uh, made discrimination based on sex illegal, what was its purpose? Was its purpose to prevent an employer from just not hiring women? Was it imagining a scenario in which there's a woman who applies and she's told on face that she cannot be hired just because she's a woman? This is a very bizarre interpretation of how a discrimination actually works. Discrimination is levied on any group based on the stereotypes, whether right or wrong, about that group. So people did not want to hire women um, during 1960s because they were women. People were not uh, wishing to hire women in many cases in 1960s because they believed that certain facts were true about women which were undesirable. And this is something that the Congress sought to attack. Take, for example, a construction industry. A person might not want to hire women in such an industry because it requires a lot of physical skills. It also requires, along with physical skills, other attributes such as ability to work hard, uh, ability to work, ability to give your full towards the job, ability to not be withheld because of things happening in your body. These are all things that a workplace, especially an industry like construction, requires from the people who are working on site. And the employers believe that the woman cannot provide an assurance, and not all things could be tested. For example, during 1960s, a lot of women also worked at home to some extent. So could they contribute fully in the workplace, lifting heavy beams, lifting heavy stones and bricks? Could these women participate in the construction industry uh, with their relatively frail bodies? What about pregnancy? How to deal with those issues in which the women want to take leave, but the employer cannot give that leave? These are all the relevant things that were going in the employer's mind, perhaps, while deciding whether the woman would be apt for the job. It is to be noted here that any discrimination that occurs based on the idea the person who is discriminating has in his mind. There is no actual discrimination just based on presence of a reproductive organ. Women are not discriminated against because they just have a different set of reproductive organs. Or men. They are discriminated in many cases, or perhaps all, because there are some uh, characteristics that are either associated with them or are thought to be associated with them, and thus they are undesirable in certain circumstances to the person who is hiring them. Hence, this argument does not hold. Because, for example, a person who is discriminating, believing that women would be a liability to his corporation because of pregnancy, uh, is discriminating on the feature Y, that is pregnancy, and not on the feature X, which is sex. But courts have long recognized that such discrimination does fall into the category of sex and would be a discrimination on the basis of sex. And this is the reason why women are provided this extra protection wherein they can take, where they cannot be denied hiring based on their future plans of reproducing. Now, this has been the case for a long time. Should Gorsuch have overturned that precedent or any of those precedents that may have arrived? George does not answer that question, and throughout this criticism, we would see this point raised again and again. Here, George is not asking to overturn the precedents which are binding Gorsuch, and Gorsuch is only one of the two ways. Either he overturns all the previous precedents that do not follow do not follow George's arguments, or he gives a decision he gave. These are only two consistent and honest positions. George then describes other things as well. He cites Justice Brett Kavanaugh's analysis, and these are all criticisms that are related to the criticism as mentioned under the first part, which is whether a discrimination based on a characteristic Y that entails from X can also be said to be a discrimination on the basis of X. And Gorsuch writes in his opinion that it would be because the analysis of Civil Rights Act follows the but-for causation. A but-for causation means that all possible angles as causes are looked into that may have caused a particular outcome. So discrimination based on the characteristic Y would also be a discrimination based on the characteristic X. If without X being true, uh, the discrimination would not have happened. And this is the but for causation. So think of it like this. X entails Y. If that is true, that X necessarily or always entails Y or is associated with Y, then a but for causation would eventually define X to be the cause of a particular discrimination when Y is the cause of that particular discrimination. And this is something that binds Judge Gorsuch. Now, should he have overturned that? That is a different question, but George does not argue that in this article. Then he talks about Kavanaugh's and Phillips's analysis. And he says in his last sentence, and as Professor Phillips's replies to critics confirm, this reading also fits the reasoning of all the court's Title VII precedents until yesterday. Yesterday's decisions contradict this faithful textualist reading of Title VII for a simple reason. An employer motivated by intent, belief, or attitude about people engaging in certain forms of sexual conduct, for example, needn't have any motivation at all that is specifically about, say, women, individually or as a group. This is again an issue because it does not take into account the but for causation. Any sexual conduct, if it is discriminated against, if it is entailed by an analysis, if it is entailed by the reality of sex, would allow the criticism to be levied, but for criticism to be levied against that discrimination, and thus would make that discrimination come under the ambit of Civil Rights Act of 1964. For example, take racial differences. If there are racial differences and someone discriminates on the basis of that, those differences and not on the actual basis of race, would that come under Civil Rights Act of 1964? Well, the answer is yes, according to past precedents. And that is also the case with sex. As Gorsuch argues, in his opinion. He says, and let's go to the relevant section. Yeah. So he says that some of those who supported adding language to Title VII to ban sex discrimination may have hoped it would derail the entire Civil Rights Act. Yet, contrary to those intentions, the bill became law. So he's talking about how few people thought that the Title VII would never become a law because it bans discrimination on the basis of sex, and there are obvious sexual differences that men and women have that people want to protect. So people would never vote in favor of Civil Rights Act, but people actually did. And from that point, it was quite clear what the Civil Rights Act entailed. That over the years, those differences could not be defended. He argues, for example, in his opinion, that this elephant about the eventual mitigation of sexual differences was never hidden in a mouse hole. It has been standing before us all along, and he's right. And that was honestly the reason behind the Civil Rights Act of 1964 and further progressive interpretations of it. So it cannot be said that this was not expected. It was expected for a long, long time. And it came in discussions regarding the Civil Rights Act of 1964 as well. Anyways, let's look at another criticism by Ryan Anderson. This is something that Fraser also cites. So, Ryan Anderson critiques Gorsuch's opinion also. Uh, he's a research fellow at senior research fellow at the Heritage Foundation, and his arguments are as follows. So, Ryan Anderson does mention the but for causation that Gorsuch cites, and Gorsuch also offers examples of how that but for causation plays out. To argue against that, Anderson lays his own claim or presents his own argument. For example, he argues, under the Gorsuch test, if changing the plaintiff's sex would change the outcome, sex discrimination has taken place. Suppose a female lifeguard is fired because she wears a swimsuit bottom, but not a top. No doubt, changing the employee's sex would have yielded a different choice by the employer. Yet her termination was not sex discrimination, provided that a male lifeguard who exposed private parts would have similarly been fired. That male and female bodies differ and thus require different swimsuits to prevent exposure doesn't amount to discrimination unless one embraces a simplistic theory. And of course, nothing hinges on whether this lifeguard currently identifies as a woman or a man. So he's giving an example. He's talking about how male and female bodies differ, and if a female lifeguard only wore a swimsuit bottom but not top, under Gorsuch's analysis, that would be okay because a male lifeguard would also be wearing just a bottom and not the top. The problem with this analysis is that, to some extent, the argument by the feminists actually argues for exactly this. The male and female bodies differentiation has been to some extent part of the law in a certain sense, but does not actually play out in the society. Male and female bodies, according to the contextualization under the arguments presented in the society, are not assumed to be different, and the standards of freedom that are applied to male bodies are almost also applied to female bodies. The difference, obviously, of course, in this case would be perhaps part of breasts and nipples uh, of the female. But keeping that aside, much of it is kind of similar. Now, this issue also discusses dress codes essentially, and this is something that we would come on discuss. But let's first look at other arguments aside from dress code. Mm, yeah. So another argument that Anderson gives is, suppose a male employee at a fitness center repeatedly goes into women's locker rooms and is fired. Now, it is true that changing the employer's sex would have yielded a different choice, but the negative treatment that the employer faced was not sex discrimination, provided that employer imposed no double standards for men and women, because each are prevented from entering the opposite sex's private space. And yet, with Gorsuch's opinion, the Supreme Court has embraced a theory of sex discrimination that prevents employers and schools from keeping males out of female only spaces. Either that or it believes that males with a transgender status have the privilege of entering female only spaces. Now, this keeping males out of female only spaces is also something that conservatives are fighting for, and so it is also very relevant here. So, let's discuss this first. If a male employee at a fitness center is going into a women's locker room and is fired, the question is asked why he is fired. Well, the reason he is fired is because there is something about his sex that is believed to be related to certain attributes about him. So, this is different than dress codes because the reason for not allowing a male employee into a women's locker room is also has to do with the beliefs about how men would behave, about how men are, and that may or may not be biologically evident as easily as the difference between male and female chests. However, the issue with this analysis is that, as Gorsuch points out in his opinion, that Civil Rights Act of 1964 deals with individuals, especially Title VII, and does not deal with groups. So take, for example, a man who wants to go to women's locker room and he is denied. The reason why he would be denied is because he's expected to go into the locker room of males, but that is identifying him with his sex. So essentially, Gorsuch's argument is that doing this also for the female is basically double discrimination. Now, this argument is not philosophically sound, but it follows from the past precedents. One of the case comes to mind is Los Angeles Department of Water and Power versus versus Manhart. So basically, this was a case, a very instrumental case, by the way, in which the employer was seeking to charge more money for pension fund from the woman. So it is a well-known fact and is backed by several studies and statistical analysis that women live longer than men. So basically, they use up more of their pension amount. Also, basically, they take more pension amount from the employers. After retirement, if a female is living even 1 or 2 or 3 years more than the male on an average, there is 3 years of salary. There's 36 months of salary. And it could amount to a lot, especially when she is not working anymore. So the employer expected the women employees to pay more. And this was ruled as against the Civil Rights, Title VII of Civil Rights Act of 1964. The argument was that all, although it was true, perhaps that the group had different characteristics, and these characteristics were measurable and could be proven by statistics. A woman could not be assumed to be put into the group of women and be denied certain benefits. And this is a very important ruling because it essentially gave women a share in the pension fund of men, because in a collective pension fund, all the people contribute towards the pension fund. So if the women were on average getting more than men because of their longer life expectancy, they were effectively eating away the share of old men who depended on that pension fund to fight out diseases, to pay for their health care, and in general to ensure an income of livelihood when they were not working and were unable to work effectively. The court even allowed that. So the court's precedent, Los Angeles Department of Power, Water and Power versus Manhart, ruled in 1978, essentially argued that no individual could be put in the category of their respective genders or respective sexes uh, uh, and be denied or granted a stuff or granted something. Now, this is a very important point because if that is indeed the case, then when a male employee is prevented from going into women's locker room, provided that he accepts that he would only use women's locker room, he is being put in a category of males and is being expected to behave as other males do. There is no difference between the two cases in the central argument because in the first, except for the fact that in this case perhaps he would not have as much evidence of so many males being or males being bad in women's locker room, but the evidence regarding the life expectancy of women is pretty more is more objective and is more analytical. So even though in that insurance case, in the pension fund case, there was an actual there was actual data that showed the difference between the groups in regards to their characteristics, it was not considered a valid argument. So why would this be considered a valid argument? Based on past precedents, this would not be a valid argument and would not have been. But the reason why this ruling allowing male employees to go into women's locker room was not debated and upheld in the court was simply because there had been a bigger public desire to ensure that women do not pay extra pension money, extra money towards their pension, even though they live longer and gain extra benefits. But public does not want males to go into women's locker room. So basically, this is related to the concept of popularity. It is a popular opinion that women should not pay more, but it is not a popular opinion that males should be able to go into women's locker room. So essentially, if the Gorsuch would have accepted this argument, he would accept it that the popular opinion defines how cases are ruled, and that would not have been in line with his philosophy or normal principles of jurisprudence. So this argument is not as good. Um, Here, Anderson cites Ginsburg's opinion, strangely, but let's read that. So the case is Onkale versus Sundowner Offshore Services Incorporated. So Ginsburg says, and Anderson cites, the critical issue, Title VII's text indicates, is whether members of one sex are exposed to disadvantageous terms or conditions of employment to which members of the other sex are not exposed. This reading by Ginsburg, Anderson argues, embraced by the unanimous court, was sound until the new theory put forth by Gorsuch, and Gorsuch's opinion ignores that sound test altogether. First of all, Ginsburg has not been consistent on the court or in his opinion, so choosing this opinion is rather strange. But the issue with that is that this opinion is basically or has been violated numerous times. Members of one sex, it's not about members of one sex being exposed to disadvantageous terms or conditions against the members of the other sex, but it's about the individuals, and this is something that Gorsuch repeats again and again in his opinion. Our focus should be on individual. Employers may not fail to refuse or hire or discharge any individual or otherwise discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individuals' sex. So essentially, uh, Anderson's argument here is not as valid. Again, let's take again the example of Los Angeles Department of Water and Power versus Manhunt. Now, once the woman, so after the court's ruling, and men and women are when men and women have been have to contribute the same amount to their pension fund monthly or yearly as the case may be, if the women are in the end getting a better deal out of that pension fund, and this is something that we can know by the law of by averages by studying the data because of their higher life expectancy, then wouldn't the ruling itself be promoting discrimination essentially? Because the members of one sex, that is the males, are being exposed to disadvantageous terms or conditions of employment to which members of the other sex are not exposed. A pension fund works exactly like that. If the males are to get less amount on average than the women from their pension fund money, from the pension fund money, that is a disadvantageous term or condition of employment to which the males are being subjected to. So this argument does not make sense. It does not make sense for other reasons as well. And let's discuss those reasons. There are many differences between sexes, and those differences cannot be accommodated just by a neutral policy. If a policy is adopted, it would benefit one group over the other in most cases. One example of such policy would be a policy regarding maternity leave, or a policy regarding inquiry into the motherhood. So let's take, for example, a policy uh, of an employer that offers women position based on their motherhood or based on their expected motherhood. Would that violate Title 7? The problem here is that if someone refuses to hire a woman because he believes that the woman can get pregnant, and he would have to offer her maternity leave, and he cannot afford that, that would be a discrimination under Title 7. But not only that is based on some actual characteristic that can be said to be aside from sex, though it is very much related to sex. The other issue is that someone may treat men and women the same by instituting a paternity leave, but a paternity leave cannot be compared to a maternity leave because they are very, very different. There would be a difference in their impact, there would be a difference in how they affect men or the women, and one group, whatever policy you adopt, one group would be at a greater disadvantage. For example, if there is uh, a paid leave that is afforded to women, let's say 24 months leave, a 2 years leave, maternity leave, and the same is also afforded to men when they become a parent. Those two things are not the same, because assume that if they are expected to be same, one must believe the role of the father and the mother would be equal at a similar stage in child's life, but that is not true. For example, a child would be dependent on uh, feeding by the mother. And if that is indeed the case, and the mother's role is very different than the father's role in the initial 2 years of child's birth, this would lead to a different effect. Uh, for example, a father himself may not find this 2 years leave as lucrative as a mother. So the major question is, who decides what is disadvantageous? How to decide that? And the answer to that question would be that it is decided by the individual himself and some reasonable interpretation or standard adopted by the court. Let's look at another argument that Anderson points towards. So he says that Gorsuch's theory of sex discrimination would rule out any policies that advert to sex, rather than only those sex-related policies that result in disparate treatment of men and women. But that is the issue. Advertising to a particular sex, or ensuring that a particular sex feels um, welcome in a particular way, would not directly transfer to benefiting the other sex in the similar way. And here, the disparate treatment would thus, a non-disparate treatment would become a disparate treatment because of differences between men and women. And this is the issue with Anderson's argument. So For example, let's go straight to something that Anderson uses. But the simple test Gorsuch applies here yields ready answers in other contexts. Just recall the bathroom and dress code examples given above. Or consider a case of athletics involving a high school male who identifies as a girl but is prevented from entering the girls' locker room or playing on the girls' basketball team. What would Gorsuch say? The principle intentionally penalizes a person identified as male at birth for traits or actions that it tolerates in a student identified as female at birth. Anderson argues that Gorsuch's position would either require the elimination of all specific programs or facilities or allow access based on an individual's subjective identity rather than his or her objective biology. This is a very wrong understanding. Let's take the example of the high school male who's identifying as a girl. Now, the high school male who's identifying as a girl would probably do that in order to play on the girls' basketball team because the girls' basketball team has lower expectations. So the male who would not qualify for the boys' basketball team, perhaps because he's not as good, would perhaps qualify for the girls' basketball team. And that is perhaps the reason why I would like to play on the girls' basketball team. Now, subjecting him to a higher standard that is present in boys' basketball team, that would be a disparate treatment. Now, Anderson's argument is that that would not be a disparate treatment because this is something that the uh, organization or the school is not deciding. But that is exactly problematic because in that case, Anderson's argument uh, would theoretically make genders equal and would lead to non-admission of reality of biological sex. So this argument is in conflict with itself, and the reason why it is in conflict with itself is because for the reason that a similar standard that is adopted or similar approach that is adopted towards both men and women would obviously result in disparate treatment because the capabilities of men and women, what they are willing to face, what they are willing to accept, are different. To understand this argument better, consider Anderson's own example. When Congress passed Title IX's ban on sex based discrimination in education, the implementing regulations clarified that providing sex specific housing, bathrooms, and locker rooms was not an unlawful discrimination. He also talks about how the Congress wishes to protect the ability of institutions, for example, to offer single sex facilities and programs on the basis of biology rather than identity. These two conditions show why Anderson's argument does not work as well as he thinks. Because just about it. If, for example, a school offers equal funding to male and female sports, according to Anderson's argument, that is not school's actions are not leading to disparate treatment. But if the performance of the males are different or are better than the female, then that is a disparate treatment. And Anderson, belonging to the Heritage Institution, which is basically a pro-capitalism institution, should realize this. It is bizarre that he does not understand the disadvantage. That would be similar to, for example, saying that someone who is or paying equal amounts of money to male and female football team or soccer team is not disparate treatment even when the performance of males is very different than the performance of females and the ability to attract audiences is also very different for these two groups. The issue is that if we believe that Anderson's argument holds, what we are looking for is that an institution would be justified in offering same treatment to men and women if, according to it, it is not disparate, if it provides accommodation to their sexes in a way in which it does not account for their sexual differences. On the other hand, Anderson is also arguing that admission of sexual differences in policies is acceptable. So these two arguments are conflicting with each other. The only way to settle those differences those distinctions would be if both the institution and the person are allowed to decide what disparate treatment is. And that was exactly done in Los Angeles Department of Water and Power versus Manhart and other cases. Now, let's go back to the argument regarding the dress code, because that is the argument that we left. So this was talking about, the argument was talking about the different dresses for men and women. Now, the issue with this argument is that in some cases perhaps it makes sense. However, in other cases, it does not make sense to have dress code unless you believe that there is a particular way the males should dress and a particular way that females should dress. If there is a person who wants to dress like female, or let's say wants to apply makeup, what is the equivalent to that? If he is fired from his job for not adhering to dress codes, what would be Anderson's response? Well, Anderson's response would be that there is a dress code for the males and the dress code for the females. But in actuality, what is the alternative for men with, uh, with regards to makeup for women? Of course, saying that these are dress codes makes it appear that there's a difference in just the dresses, but that is not the case. For example, imagine offices in which women are not required to wear makeup but are allowed to wear makeup, but men are not allowed to wear makeup. Now, one cannot cite dress code as the reason behind this difference is because females are not required to wear makeup. But if the male wears makeup and if he is fired, the argument would be from the Anderson side that there is something available to male also. But what would that be? And this is something that perhaps Anderson has not thought of. The issue with Anderson's argument, in a nutshell, is that what is disadvantageous would depend on the individual and not the group. But if one understands that what is disadvantageous should be analyzed on the basis of the group and not on the basis of the individual, then a lot of precedents would have to be shot down. And that would be particularly problematic. Because in such a case, one clearly arrives at a situation in which a lot of men would not find a particular reward or a particular penalty as appealing as the woman, and may think that it is disadvantageous towards them. A good example is, for example, wearing tie in offices. Is that disadvantageous? Why should only men wear tie in certain offices? This is not a small criticism. This is a big criticism because men would find it certainly very disadvantageous to wear something that does not allow the movement of their neck for 8 hours every 5 days in a week for the rest of their lives up until they are 60 years or 65 years of age. That is pretty disadvantageous, wouldn't one say? Any sort of standard that is adopted towards men and women because of their differences in their sexes would either not benefit men, in most cases at least, as much as it benefits the woman, or vice versa. For example, uh, any payment that is made, for example, or any, for example, if a company provides uh, cabs for its employees, for females it might be particularly good option, but for the males it might not be. For the males it might be a worse option because males perhaps can go and travel in public transport better. Perhaps they would like a remuneration against the provision of those cabs, and that is dependent on their biology, perhaps because they can stand for a more amount of time in those public transports than the women, perhaps because they feel safer traveling at night, or any of those issues that are generally talked about in the culture. So, how can those two issues be equal? This is the problem with Anderson's argument. The issue with Anderson's argument can be pointed out by looking at Gorsuch's opinion itself, and I will point the relevant section. This is this relevant section. In Phillips versus Marietta Corporation, a company allegedly refused to hire women with young children, but did hire men with children the same age, because its discrimination depended not only on the employee's sex as a female, but also on the presence of another criteria, namely being parent of a young children. The company contended it hadn't been in discrimination because of sex. The company maintained, too, that it hadn't violated the law because, as a whole, it tended to favor hiring women over men. The court rejected that argument. There is clear difference between men having children and women having children, young children. And that has to do a lot with the fact that, as argued, a woman's job during the initial years of child is very different than a man's job during initial years of the child. And maybe company had a point there. There are certain things that follow from a woman having children, which a company may feel undesirable for its own cause. Maybe it is the fact that the woman who is very tired after looking because of looking after young children is not able to be as productive or as efficient in the company. Maybe it's because of any of the numerous reasons that can come in mind because of different roles that men and women play in raising their children. But those arguments were not accepted. The reason why those arguments were not accepted is because there was an there was a factor of sex there. Similarly, in Onkale versus Sundowner Offshore Services Incorporated, which is a case that um, Anderson cites, it's a very important case because in that case, a male plaintiff alleged that he was singled out by his male co-workers for sexual harassment. The court held it was immaterial that the members of the same sex as the victim committed the alleged discrimination. Nor did the court concern itself with whether men as a group were subject to discrimination or whether something in addition to sex contributed to the discrimination, like the plaintiff's conduct or personal attributes. What they thought there was that the plaintiff, that is, whether the plaintiff would not have suffered similar treatment if he were female. And because they thought that that would not be the case, a tribal Title VII claim existed. Anderson, in regards to Enclave, this very specific case, talks about disadvantageous terms that the individual faces. And this is a very important point because it is talking about the individual and not the group. As pointed out earlier, the opinion of Ginsburg in this regards is whether the members of one sex are exposed to disadvantageous terms or conditions of employment to which members of the other sex are not exposed. In this case, would that disadvantageous condition would inherently be dependent on the sexuality of the male co-workers, and thus it includes sexual orientation within itself. For example, In another point, Gorsuch argues uh, yes, so this is example that Gorsuch gives. Suppose an employer fires a woman for refusing his sexual advances. It's no difference for the employer to note that while he treated the individual woman worse than he would have treated a man, he gives preferential treatment to female employees overall. The employer is liable for treating this woman worse in part because of her sex. Nor it is a defense for an employer to say it discriminates against both men and women because of sex. This statute works to protect individuals of both sexes from discrimination. Now, this case in which an employer fires a woman for refusing his sexual advances, this is a normal case in which sexual harassment could be thought of sometimes as sexual discrimination. But sexual harassment cannot be sex discrimination, unless one's sexual orientation is taken into account. If an employer is, for example, uh, not heterosexual, then perhaps it will be more likely to believe that he does that also to men. Maybe he's bisexual, and he treats both men and women as similar, and both should accept his sexual advances or get fired just by knowing that whether someone is male or not. It does not uh, tell us whether firing for sexual advances is sex discrimination, and it invariably talks about sexual orientation of the employer and perhaps the employee in question. And this shows that the concept of sexual orientation in regards to the category of sex has been procedurally linked and cannot be separated too easily. Now, could Gorsuch be expected to overturn this precedent also? Perhaps he should have, but that is not what Anderson argues. So ultimately, the whole question becomes whether Gorsuch should have overturned a lot of precedents that goes against Anderson's view, or should he have retained them and gave a ruling as he gave? And he chose the latter option, and perhaps it is not the best option based on philosophical analysis. But the question here is not about the philosophical analysis, it is about the legal analysis of Civil Rights Act of 1964, which by its very nature was created to destroy stereotypes regarding these particular categories that are included in the act. And its role was obviously to shatter gender stereotypes, for example. And there are many cases that talk about how the employer cannot discriminate against a feminine woman, a feminine man, or a masculine woman. And those cases also set precedents. According to Anderson's view, those cases would not set a precedent because a male can be expected to have masculinity or masculine behavior, and a female could be expected to have feminine behavior. And thus, both of them are treated in a similar way. But that was not held in many rulings regarding the primitive way of understanding gender orientation among males and females. So Anderson's case is also on shaky grounds. Now let's go back to Fraser's argument. Fraser says, where might someone learn a style of reasoning so tortuous and sophistical? It can read an implicit reference to sexual orientation and gender identity out of the word sex as it was understood in 1964. Fraser is right. Gorsuch's opinion is philosophically not sound, and Alito and Kavanaugh point this out succinctly. But the question here is not that. The question here is whether it is legally sound. And based on past precedents, unless Gorsuch had overturned them, they are.